The defense wants to negotiate. They call your attorney and now they start to negotiate. And your reaction is no, 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 without making any counteroffer. Is that a good strategy? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. I have a few minutes to share this great information with you. So now you brought a lawsuit against your doctor claiming that he was careless, causing you significant harm and injury. Now, at the very beginning of your case, the defense has notified your attorney that they have no intention whatsoever of ever negotiating or settling your case before trial. So you become resigned to the fact that you will have to go to trial in order to determine whether you and your claims are slightly more likely right than wrong than what you are claiming is true. Now, 2 years go by. The litigation process has proceeded. 2 hard, long years. And now your case is on the trial calendar approaching trial. A few weeks before trial, your attorney gets a call from the defense, and now they want to start negotiating. Your lawyer calls you up and tells you about this. Your first gut reaction is absolutely not. I will not negotiate with them. They wasted 2 years. Now, for the very first time, they want to start talking? No. You tell them absolutely not. And your attorney asks whether you want to make a counteroffer. And your initial gut reaction is no, absolutely not. They tortured me for 2 years, telling me they would never settle or negotiate, and now here they are trying to negotiate. This is outrageous. No. So now your attorney goes back and says, thank you for the offer, but we're not interested. When that happens, do you think the defense is going to come back and say, please, please start negotiating with us. We'll offer you more money. So let's say you think your case is worth $2 million, and now they came in and they offered $1 million, and you simply rejected it outright. You said no. You think in the back of your mind that if you continue to say no, they are simply going to continue coming back to you and your attorney with additional money each and every time. Okay, $1 million won't do it? All right, how about $1.1 million? No, that won't do it? How about $1.2 million? Okay, how about 1.3? I will tell you that that strategy, that perception, that thinking may not be ideal for you in your case, and I'll tell you why. Doing that, the defense is at a huge disadvantage. They don't know where your end point is. They are going to be bidding, literally, against themselves. They will appear very desperate to try and settle your case by doing that. Please, please take our money, get rid of this case. We want to settle this case now. Well, that may be true that they are desperate now to try and settle the case without going to trial. However, the strategy of them continuing to offer additional money, not knowing how much you are willing to accept, not knowing where you think this endpoint will be, where you will ultimately say, yes, that's the number, that is likely not going to happen. And they are not going to come back and simply increase their offer each and every time, every few minutes. Okay, we'll give you 1.2, we'll give you 1.3, and now incrementally increase it to at some point down the road, not knowing when or if ever, you and your attorney say, okay, that's the number. Case is settled. That's not how it's going to work. In fact, with your attorney continuing to reject the defense's offers, that tells them that you and your attorney are not serious about trying to settle this case. It might be a better strategy to simply come right out and tell them, listen, we're not interested in settlement discussions. We want a jury to make a decision about whether or not your doctor was careless, about whether his carelessness caused or contributed to the injuries, and if so, how much those injuries are actually worth. In that instance, now you're basically telling them straight out, don't bother coming back to us with any offers or any further offers. We are not going to entertain them. We want a jury to make a decision. And you might be thinking, why now? Why after 2 years of hard-fought litigation are they now willing to try and negotiate? And the real simple answer is, now they've had the case fully evaluated. They've had medical experts review the case. They've analyzed the case. They've presented the case to their insurance carrier. And now they have come to the conclusion that to try and minimize the risk of a jury reaching a verdict that would be far in excess of any particular settlement number that they could offer, they are trying to minimize the risk and now try to offer something that they think is appropriate for your particular case. That's why they're now coming up with this number. And at the very beginning of your case, when your case started, it was just a gut reaction by the defense attorney to say, we are never settling this case. The reality was that they had no ability to analyze your case at the beginning. They didn't have all the records. They didn't have an expert review it. They hadn't analyzed it. They hadn't presented it to their insurance carrier. It was simply a knee-jerk reaction saying, we're not going to settle. But you are so incensed. You are so upset. You are so frustrated with them for not ever trying to negotiate with you during the 2 years the case was in litigation. Now, when they come back and say they want to start negotiating, your reaction is, no, 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 I will not entertain a $1 million offer. I will not entertain a $1.5 million offer or anything else. So you instruct your attorney, tell them, we're not entertaining any further discussions. We'll see them at trial. So why do I share this quick information with you? I share it with you just to give you an insight and to open your eyes into what happens in these medical malpractice cases in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.